Side number 30.
I remember the last is the Bombay High Court. Number of the issue here is this court pass an order at page.
You are in appeal against the order dated 29th of October. Before only
The appeal has came perfect. But appeal
and
has
you have also filed an appeal against the order dated 15th July, which
yes,
is
the both are,
still to come up.
yes, both are pending.
Second, just let him also know what is.
Yes.
You have also filed a writ petition against the order dated 15th July 2024 before Honorable Bombay High Court.
Yes.
That order was considered and remanded back to us on limited aspect. Then we passed the 29th October order.
Yes.
So now, in the light of doctrine of merger, how can we recall this order?
My lord, first thing, the lordship has said merger. What is a merger? What is a res judicata? What is transitive res judicata? What is, so the question is, what is a cause of action? Cause of action, Harsbury has defined as a bundle of facts, which disputed facts. Before that, Harsbury, I must go to Chief Justice Court. Cause of action is a disputed evidence. When it is subjected to adjudication, it transforms into something else. The process is called transitum rem judicatum. And if the cause of action is found to be in existence, it merged with the decree of a court, and thereafter ceased to be in existence.
If I can be excused, my learned friend can continue. I can.
So, cause of action, if when undergoes a process of adjudication, that process is called a transitum rem judicatum. And if the cause of action is found to be in existence, it merged with a decree of court, and that is called merger. Thereafter, the cause of action dispute evidence ceased to be in existence. The Chief Justice Court has said in uncontrollable verity. The word terminology used is uncontrollable verity. Court on Littleton. And there was there's a book called Everest on Estoppel. Everest on Estoppel, Asperus on Estoppel, Berero on Estoppel. I have a number of classical books on that. So, when if the cause of action is not to be found in existence, there is no merger. If I say this is my property, and she claims it is her, and the court finds that it's mine, then the cause of action, the disputed evidence, the merge with the decree of the court. That is a merger. Suppose the court finds against me, it is not mine, then nothing merges. Then it is called res judicata. Res judicata pro veritate accupator. None of this, our law has come from where? From Rome. So unless we know basic Latin, it is difficult to be a good lawyer. And it is difficult to understand jurisprudence in a proper sense. So therefore, why I am here is, the concept of res judicata is applicable to facts. Ulpian said there are 5 great lawyers: Ulpian, Papinian, Gaius, Modastinos, and one more.
Please argue your application, Mr. Please argue your application.
Yeah, I am only arguing that. I am arguing that this court has, I come here very peacefully to argue. And if I am not allowed to argue very peacefully, I will not fight anything. I will not even assert my right.
You allow us to function peacefully.
Therefore, I will put across what first I can say in the most calm and cool way.
Yes.
If it is permitted, I will argue. If it is not permitted, I will not have anything. I will say I am permitted to relinquish my brief. Let the party engage somebody else. Yes. So therefore, all this point which the lordship has been, the one member has been pleased to point out is that an appeal has been perfect, a repetition has been perfect, and these matters are before some other forum, and therefore this tribunal has jurisdiction or not. That is the question which is put to me, and the answer there is this tribunal has got every jurisdiction. If the tribunal has no jurisdiction. And the coming here would be an entirely futile exercise. I wouldn't be coming here. I came 1 hour before I was waiting. I wouldn't be coming and waiting for this item to be followed. So this tribunal has got absolute jurisdiction. The tribunal jurisdiction is lost the moment the appeal is finally decided. The appeal is finally decided in my favor, then it may lead to merger. If the tribunal decides, the appellate tribunal decides against me, it is certainly leads to res judicata. So let us the distinction between res judicata and merger, for our purposes, have no relevance at all. What is relevant is the concept of cause of action estoppel. The estoppel in res judicata. Somebody said about judgment in Trump. I said somebody wearing a different gown. Most people have no idea what is judgment in Trump. I'll come to that. Yeah, yes. Therefore, there is no adjudication of the only an appeal has been filed. And this issue I had occasion to argue before the Supreme Court. My client.
What is your application?
No application for recall or reconsideration.
Argue that. Tell
That is
argue that.
I'm saying.
Yes. Therefore,
He doesn't come to point actually.
no.
He will come to the point.
No, that is, your worship, they cannot say make such comments also because it's painful. I'm in the bar for more than 41 years. And before that, 5 years, I was a litigant even. So I argue about so many matters. There were so many before, there were so many.
Let us come to your application.
Yes, I'm coming to my case. Now, the issue, what is my case? Let me say that. My case is simple. I'm an MSME. I'm a registered MSME. Registration is not required, but I'm a registered MSME. There is a notification dated 29/5/2015 issued by the central government under Section 9 of the MSMED Act.
We have dealt with in 29/10 October this notification.
Pardon me?
We have dealt with.
No,
this
there are members.
No, no, I'm asking you.
Yes.
We have dealt with this notification in 29/10.
No, I am only saying that this order of this tribunal, the order of this tribunal is rendered per incuriam. It is void because without jurisdiction. The plea which I raise here is not this. I am not coming here saying that this tribunal said on facts 1 + 1 is 0. No. This tribunal says 1 + 1 is 0 on facts. I have no quarrel. I may be certainly not be happy with that. But the tribunal has power to say so. But the tribunal has no jurisdiction to err on law. The orders of this tribunal dated 15/7/2024 and 29/10/2024 are all vitiated by errors apparent on the face of the card.
So that order.
Error apparent on the face of the card.
Yes. That order of 29/10 for his sake of his knowledge. For order dated
Yeah, I am thinking
29/10
that.
of 2024 was challenged before Honorable Bombay High Court again in writ. Heavy cost was imposed against you. That order was not found of containing any patent error or lack of jurisdiction. No, please, understand. And that your civil appeal before Supreme Court was dismissed against that order. Now you say what you want.
Therefore, I am saying, that is the point I am saying the difference. On a question of law, the point I am saying is, on a res judicata applies, the bar applies only on facts. If I say something in Latin, what should you say? I'm saying in Latin, I'm quoting, it makes point very clear.
No, we have started learning
See, because these are fundamental principles. Therefore, the court has a freedom to err. One is supposing that court has said 1 + 1 is 0. I have no right to come here. I will not come here. I am coming here. The error which the court has made is on jurisdiction. And jurisdiction error, I don't believe in citing judgments, but I take some judgments also very recent as Justice Nariman. If somebody has a quarrel about my using Latin, then I take your lordship to, this is a judgment of the Supreme Court. And deviate, first I say the first principles, then I go to judgment. And if you know first principle, there is no need for judgments. These judgments are all waste of stationery. Yes. May I take your lordship to page, before that, may I take your lordship to page 239. 239. This is judgment by
But
this is
was
valid.
what? This is what proposition you are trying to.
No, the proposition is there is no estoppel against law.
We know
No,
that.
but if that is not accepted. If that is accepted, then this question wouldn't have come.
No, you answer your application.
Yes,
See, we
yes.
have a fixed match
Yes,
at
yes.
12:30 also.
No, now may I take your lordship, may I take your lordship to page 239. 239.
39.
Rohindan Fali Nariman. Rohindan Fali Nariman. Roma locuta est. Casa finita est. Roma has spoken. The case is closed. That is correct. Case is closed is right. Yes. There's a reason why it is Roma locuta est. That's a lot of jurisprudence I am not saying. Rome has spoke through her laws. One of the pillars of Roman law is contained in the maxim "Prosudicata pro veritate accipit." Yes, a thing adjudicate receive as truth. This maxim of Roman law is based upon the other two fundamental maxims: Inter republico ut sit finit litium. It concerns the state that there be an end to the litigations. Yes. No more about this. Sorry, bro. You know at
Mr. Counsel, we have
no
a
man,
fixed-
no man shall.
We have
No
a
man
12:30.
shall be on.
Mr. Counsel, we have a fixed matter.
No,
12:30.
fine. Your lordships are asked a question.
We are posting at 12:30 on another date. We'll give you 1 hour. You
Yeah, but therefore, I don't
decide whole Ramayana.
I agree. Then fine, agree. All that.
19th August, 12:30.
Agree.
One hour.
Since you know.
No, we know about this.
No,
There's
no.
no need to.
My lord,
cite
my lord,
it.
I know humility. I'm a student of law. I've never seen that somebody who knows actually law.
No, we.
I
we
have
know about
heard,
this.
I heard Fali Nariman. I have heard Mughal Lord. I have heard many people. As a student of law.
Mr. Counsel, we do not know the law. That is why you are coming for the call now.
Therefore, my lord, one day.
You have to stick to your application. Please.
I'm saying answering a question.
19th August, 12:30.
If the question is accepted, there is no estoppel against law. And then the question of the question with the judicial member asked has become irrelevant. There is no estoppel against law. There is no finality, and therefore I'm addressing the matter afresh.
The counsel for the applicant commences argument. However, this bench has fixed matter at 12:30. Post this matter at 19th August, 12:30.
12:30.
So, which date you are?
19th August.
19 August 12:30.
19th. There was something going on. The CRP proceedings are going on.
That is why we are not concerned with that.
No, I am
obtain
concerned.
a
The court is not concerned.
Learned counsel, we are before every
The
court.
court is
We
not
are before
concerned. I am
every court.
concerned.
You obtain a stay, you are bound by that.
It is my blood and matter.
And you ask your client
Yes.
to learn how to behave in the court. Okay, please.
No, I don't want to open. You know, the
Take it,
Pandora's box.
please.
Let Pandora's box remain
Ah,
closed.
yeah.
I want peace. I won't want to say anything.
Yes. Chalo. 19th August.
19 August 12:30. Next. Next item number 31.
Out of record. Fali Nariman, Rohindan Fali Nariman using all maxims. He convicted me for contempt of court, and he said I used prohibited using Latin maxims. This is the system.
All right, we'll see.
I'm 67.
We will
I'm
learn
here.
on.
I'm 67. There's nothing to be lost. 67. We are
Your Lord,
chairman. So we will reform the system.
12:30.
Your Lordship, in serial number 31, I appear for the erstwhile resolution professional. This is an IA for avoidance. This is an avoidance application. Your Lordship,